with just a seat, a breath, and a choice. Mediation doesn't ask who wins, but it asks what survives. Because the best solutions are not crafted in courtrooms, but they are crafted in spaces with hearts and minds resolved to walking away with dignity, with transformation, and respect. Welcome to the Alternative Dispute Resolution Center, the Resolution Made Easy series. My name is Nanza, your dispute resolution strategist and the executive director at the same. Today's series is going to focus on mediation, and this is why. Have you considered getting into a dispute resolution space, or when you really have an issue that you need to resolve, interpersonal, institutional, even nations as we have seen them, and the last person you want to be in that room is someone who knows your history, someone who knows your weaknesses, somebody who knows things that when brought out in this dispute might make you shake a little, make the hairs at the back of your neck stand a little, because it's a vulnerable space and you are not sure that you will recover, not just from the outcome of this dispute, but from the baggage that you carry outside, way beyond the walls and the years of that conflict. I have been in many a space as a mediator, as an arbitrator, where the only thing left to save is face, is dignity, and closure. Mediation is one of those alternative dispute mechanisms that offers just that. A neutral, non-judgmental space for you to be heard beyond words, to be listened to, not just to give you a settlement, but to resolve a dispute from an intrinsic level as much as it is an external show of discord and disagreement. Today we'll talk about mediation in light of our option analysis that, as we have been studying and understanding over the course of the discussions that we've had, is a method that looks into disputes, that look to long-term, collaborative, strategic relationship restoration and building. What does mediation do? What can mediation not do? Let's have an honest conversation. To recap a little bit what mediation is, it is facilitated, structured negotiations where parties, institutions, and nations that are struggling with an impasse invite a formally trained, or sometimes not formally trained, but highly respected third party into their dispute, with a hope that this person will not decide an outcome for them. But this third party has the capacity and they have built the trust in this person to help them speak, to help them design a course and a process that will enable the parties to come up with their own solution that works best for their circumstances and everything that surrounds dispute that sometimes needs to be preserved for the sanctity of relationship building, current or future. Let's quickly remove the myths and dispel the misunderstandings and misconceptions around mediation so that we get into the good and the juicy parts from the get-go. What won't mediation do? Mediation will not help you if the dispute has crystallized. If the cement has dried and there is no goodwill, mediation is not your best option. Please look into the other options that we've been discussing over this series so that you do not waste time in an outcome that will not be sustainable and it will not build the relationship. Mediation does not help parties where there is a power imbalance. If there is an obvious overt power imbalance and somebody has too much power over the other party in dispute, mediation is not going to help you unless there is a way from the skilled negotiator or from the other dynamics, whether statutory or other cultural dynamics that allow, before even the mediation starts, that the ground can be leveled. Case in point, we can talk about mediation in the social setting where we say if it's a parent-child situation and you realize that this child has so much fear, they won't even be able to speak their mind in the sessions, in the dispute resolution, that you ask that maybe the parent doesn't have to be in at the time where the child is speaking their truth because you want to reduce the power imbalance. But once a scenario presents itself and power imbalances cannot be ironed out, wrinkled out, then mediation will not help. When else can mediation not be a good solution? If somebody's life is in danger and you need to protect them immediately and take them away from harm, if something or a property or a place is in danger and is likely to cause harm to residents and you need an injunction to stop further action, or you're supposed to cause some action to protect people that requires immediate or emergency, then mediation will not help. When else will mediation not help? Mediation will not help parties where the relationship or the goal of one of the parties in dispute is to name and shame. For example, if you are advocating for something and you want to put the bad guy or the bad guys out there, then mediation is not your option. If you want to expose, for example, a bad company culture or an exploitation or fraud, mediation is not the place for you, because why? The very things that make mediation your best options are the ones that will not work in those circumstances. And what are those things? Mediation has to be voluntary. You want to be in the room, you have to cautiously, we work on consensus for the parties to get a resolution. It has to be voluntary, not forced, not mandated. The next thing you want to work on as you consider mediation is confidentiality, as mentioned earlier, that you know from the get-go that whatever you discuss in the room, and that is a benefit, will not go out there, but most importantly, that the relationship and the scars and the hidden parts are safe. So confidentiality is another thing that mediation will offer you as a user. The other part of mediation that is very, very key is that where other ADR options, emotions and hard stances and grandstanding can be tolerated under laws, under obligations, under limitations of time, under qualifications in the rules and strict rules of evidence, mediation is a space where you are allowed to bring feelings in the room. How about that? To think that when you're an aggrieved party, considering the other option, you have to find a clause, you have to find a law, you have to find a precedent that supports you. Otherwise, it doesn't matter what truth you hold as the person in the conflict. It doesn't matter if it cannot be supported in any law. Mediation rooms are healing rooms where you can bring your burdens, where you can bring your truth, and you will be listened to and you'll be understood from a very individualistic level without any judgment. I'm just touched about the issue of evidence and strict rules of evidence as it is in traditional courts. In mediation, you can even bring the neighbors. You can even bring anybody from your childhood, anything that will make your story be heard, that allows the mediator, a skilled mediator, to understand the gist of your conflict, besides just carrying lawyers and professionals in the room. The other misconception that we need to deal with head-on in mediation is gender, is race, is age, and profession. We do have a change in the way dispute is being resolved through mediation, that is no longer about the oldest person in the room, the most qualified person in the room, is typically not the oldest by age. It's no longer for a certain gender that they are mediations where only men can handle them or where only women can handle them. As we have sung over and over in the discussions we've had, mediation comes down to the soft skills of the individual that you're trusting with your dispute. I want to share a lot on the side of how mediation happens for those of us who are encountering it for the first time, to understand, because these concepts can be very abstract if all you've known is the straight-jacketed, confusing legal jargon in legal terms, the courtrooms and their cold, sorry to say, wood bench, and the air that is thick. Mediation, when you come and choose it as your option, first and foremost, you choose the time, you choose the place, you choose the mediator, of course, based on your interests, based on what you value most, and you agree. Choosing a place where you're going to have your dispute heard means that you are going to control typical things that would cause one to be stressed out, from dress code to the lighting, when you will have meals, when you will take a break, when you step aside, and how the process will be managed. The role of a mediator in any mediation, right, is to give you mastery of the process and not the outcome. If you want an outcome that is dictated to you by subsection A of this code, of this act, then mediation is not the place for you. That means that you, as parties in a dispute, whether it is your corporation or your individuals, you come together, be heard with an expert third party, neutral, under confidentiality, and they help you and guide you along to determine the outcome that best works for you. I will give you a glimpse, even though this is not a mediation masterclass, of what typically happens. When you come and we've agreed on what you're going to resolve, and the parties have agreed on the modalities, we hear each other out by setting out ground rules. I would typically introduce myself and let you know the reason you're there, and we agree that you're there on a consensual basis, and we start to talk. Why do you think you are aggrieved? Why do you think this is not right? As we discuss what I call preliminary, we get to hear the general, the heart of the dispute, and that is where skill kicks in. Typically, when you've had the first round of submissions, we are not yet at the core, at the gist of a dispute. And there's a bit of grandstanding, stonewalling. Some parties are moving gingerly, especially some of the disputes where you either have lawyers involved, they come as counsel, or elders, and the parties in a dispute are not yet free to speak. Important to note is when we are in mediation, the lawyers or the professionals don't speak for you. A good mediation is where you, the party that has the issues, that knows the history, that knows the pain, that knows the options that you had, that knows your thought process that led you into this dispute. You speak for yourself. So there's no such thing as speak through your lawyer, speak through your cousin, speak through your elder brother or your grandfather. We encourage the parties to say their truth, and we listen and we don't judge at all. So when that process is done and we've heard you, we do what we call caucusing. Caucusing is where the magic happens. We separate the parties into different physical spaces and we let them let loose. It is amazing when you are in a caucus room to watch. Honestly, it's like a movie. To see the dispute take shape and form many a times completely different from where you started when the parties came to you as a mediator. You see pain, you see real human conditions when they feel there's an impasse. We observe personality types. We observe a lot, like some kind of fight, you see someone trying to bring through their heart in a matter, then you see their limitations, you see their true communication versus what they were saying, but most importantly, you start to see a way out of an impasse. If you're skilled enough, and as you do the what we call diplomatic shuttling, sometimes you have to juggle between the two parties until you start to feel what we call the WIFO. What is in it for me? Every party has that point. And as a trained mediator, you start to feel it and you understand that we are getting close to something right there. I like to tell stories in mediation, I like to tell stories in ADR because they bring the message home. In this particular story, I will bring in a family situation of wrongful death. A gentleman who had served time in prison, we don't need to get into their past, had been released to freedom and had come back to life. Needless to say, at the time they were incarcerated, they had lost time with their family, that is his wife and kids. Bear in mind, this was a neat, happy family. Problems come, father goes to jail, comes out of jail. The backstory is this particular husband and the wife had been high school sweethearts. And of course, as it is with some love stories, love never ends because somebody went to jail. They come back and try to pick up their life pieces. Of course, the gentleman is reformed, and even more than ever before, wants to make good with his family, tries to make a life for his children who are now grown, getting into different spaces, and wants to make an honest living. But as you might expect, even finding a job after prison is hard. So he settles for what we call blue-collar jobs and decides to find whatever work that will bring him an honest living to fend for his family. He starts to work with a company that deals in heavy lifting, like heavy lifting and fork lifting. And of course, he needs to get training. Some point in his orientation as he's getting this training, they are lifting and offloading a big container from a heavy-duty truck. And as they stop to park and his trainer is showing him, he steps out of the car and they have to reverse park in order to displace this container. Sadly, what happens is there's also, like, most premises, there is a security guard, he's telling them back up, move behind. So the driver doesn't see the gentleman, the trainee, the father in this case, but the security guard, he can see signaling him to park. He moves the car, and as they disembark this container to land it down, it hits the gentleman and he dies. It's a sad story, but it's wrongful death. A guy trying to make a good living and give himself a second chance, but he dies. Of course, there are issues to do with insurance and who's at fault and all the legal as we know it, but I would like us to focus on the mediation part of this story and how mediation helps. When the family of that gentleman that died seeks redress in mediation after the gentleman has died, these were some of the things that the mediators had to consider. Mediation is hard and soft, and much as I personally call it the soft spot, the human face of the law, it does not disregard the law. The claim for the people who had lost, the bereaved, let me call them, or the complainants, and the people who apparently, or who are seen to have caused this death, in terms of monetary value, was from here to Timbuktu. We are talking double digits in millions and less than thousands in what was being offered. So the back and forth begins, the caucusing, the emotional testimonies of the children, the girl who feels like she had just one chance to reconnect with her dad, but was short-lived, the wife who had lost her high school, long-term sweetheart, the company that claims that the security guard who didn't work for them was the one to blame, and the back and forth. Like we said, the focus today is the mediation and not the legal aspects. And if you like for me to get into those at another time, maybe we can have a session to break down the legal implications in such a scenario. Fast forward to the caucusing. The mediator, we have roles, and this is where it becomes tough, the carrot and stick. As a mediator, I have a duty to separate my emotions from the facts of the law. In this particular case, there was an issue of what we call the rights of the parties versus the facts. Without getting into the details of these people's arguments and their points, as a skilled mediator, it was well within my rights to come and explain to the party, outside emotions, understanding that you lost a father, understanding that your future was short-shined, and but there was also something called economic loss. There were things to consider into grief. There are parts in law which you can rightfully claim for compensation and some which you not. So to sit down with this party and have the wisdom and the balance to separate facts from emotion, and to get this other party that was grandstanding to a humane place, and not to throw facts and laws towards this family that has lost a father, is a unique skill that only mediation can craft. If you are to strictly follow the law, this was the risk that we shared with the parties. Yes, you have grief, you have loss of comfort and future, whatever, but in the real sense, you cannot go to law and quantify how much you would have benefited if your dad had lived another 10 years. And the minute you lose this chance to mediate and get the best alternative that you can get, what we call the best alternative to a negotiated agreement, then in court there's no coming back. So we had to have a hard and tough conversation with this family to show them the facts of law and where they stand. The same with this company, that depending on the judge that they will find in court, if these children and the wife and their counsel have a good case and they can prove, then whatever their offer is, once the court decides, might get higher, but most importantly, the relationship will be severed for life. Why am I bringing this story? Is to show you the delicate balance where unique strategy and crafted, curated outcomes can be best achieved, not when the law sends you statutes and precedents, because we can never compare two cases of people who have lost a father and say this one's grief was watch this month, so your grief, we quantify it in monetary terms. So, in a nutshell, mediation gives you an option to curate options with the hands and the guidance of a professional who has a human heart and a human face and can converge the law, bearing in mind the different aspects that people have feelings to, and bring a human-facing solution to a dispute, for example, the one we just shared. There is a lot that goes on that we cannot talk about in these 5-10 minutes that we have on this. But please do consider, if you are out there and you are ever in need of support in a decision, when you are faced with a problem, reach out to the ADR Center. I can't tell you enough about the team that we have handpicked to help you in your options analysis, to support you in your dispute prevention, even before disputes arise as corporations, as entities. We have tools, we have a toolkit, and we have methodologies to forecast, to support, to engage before you enter a contract, after you've entered a contract and you want to wiggle room to resolve dispute in certain ways. We have hybrid mechanisms where we can guide you that, based on what you want to do for the next 5 or the next 10, maybe you need to put a clause that gives you this option first, start with negotiations, start with mediation, and then leave room with structure and define timelines outside your traditional thinking to resolve disputes as they come. I would like also to invite you to the ADR Center to engage, not just about mediation, but the other options, so that when we sit with you and strategize and craft and bridge fast this knowledge gap, you as a user get empowered. But even you as a professional, like I mentioned in the start, this is not only for lawyers. When a client comes to you, you are empowered, not just from a financial motivation angle, to support and give the best and give a meaningful solution to your clients in order to give them pathways and partnerships to resolving conflicts. Our contacts are well stipulated on this platform. We have a website, we have a social media, we have phone contacts. Let's talk about your dispute. Let's resolve disputes in a meaningful way that will return a human face to the face of law. Thank you very much, and see you in the next one.